Hello and welcome to LiveLaw Daily. Today is the 20th of July, and even with the national capital being in the grips of one of the biggest protests it has seen in recent memory, the courts keep going. And here's everything you need to know. For our first story today, the Supreme Court has refused to interfere with the Delhi High Court's decision quashing the Ministry of External Affairs tender process for outsourcing consular, passport and visa services at Indian missions in Abu Dhabi, Kuwait, Singapore and Canberra. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bhakti and Justice V. Mohana dismissed the Union government's challenge to the High Court judgment. At the same time, to ensure that passport and visa services are not disrupted, the court permitted the Ministry of External Affairs and Engineers India Limited to make temporary arrangements until a fresh tender process is completed. During the hearing, Solicitor General Tushar Mehta argued that the Delhi High Court had wrongly quashed the tender process and maintained that the evaluation criteria had been applied based on each bidder's individual competence. However, the Chief Justice observed that the government had invited the High Court order by not giving grounds for its evaluation. Justice Joy Mallya Bhakti also noted that this was precisely the flaw identified by the High Court. He observed that if the terms governing the assessment of bids were unclear, the government could not alter or reinterpret those conditions after the tender process had already begun. The Supreme Court ultimately agreed not to interfere with the High Court's finding. In its July 15th judgment, the Delhi High Court had held that the technical evaluation of bidders was arbitrary, opaque, and lacking in transparency, noting that identical proposals had received different scores across different Indian missions without any disclosed rationale, in violation of Article 14 of the Constitution. The Supreme Court has now directed the Ministry of External Affairs to complete a fresh tender process, preferably within 3 months, while making it clear that any interim arrangement for passport and visa services will purely be temporary and will not confer any advantage on any bidder. And for a second story today, the Supreme Court has observed that the alleged theft of donations meant for Ayodhya Ram Mandir should be treated as a criminal investigation and must not be politicized. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bhakti and Justice V. Mohana was hearing a batch of petitions which sought a CBI investigation and an audit of finances of the Sri Ram Janmabhoomi Teerth Kshetra Trust. Appearing for the Union government, Solicitor General Tushar Mehta informed the court that the Uttar Pradesh police was already investigating the matter and that 8 persons had been arrested so far. He submitted that a status report had been filed before the court and that the investigation was ongoing. Responding to the submissions, the Chief Justice remarked that this was a simple case of commission of offense and cautioned all parties not to politicize the issue. The bench said that it would examine the state's status report before passing further directions. It also asked the Solicitor General to obtain instructions regarding the possible reconstitution of the Special Investigation Team, while emphasizing that the investigation must be fair, transparent, and taken to its logical conclusion. During the hearing, Senior Advocate Devdutt Kamath, appearing for some petitioners, raised concerns about the alleged disappearance of gold and silver offerings and suggested that donation receipts must be published online for greater transparency. The court, however, declined that suggestion, observing that such a system could invite false claims. At the same time, the Chief Justice stressed that proper records of donations must be maintained wherever receipts are issued. The matter has now been adjourned to enable the Supreme Court to examine the state government's status report before deciding the next course of action. And for our third story today, the Supreme Court questioned the Bar Council of India's opposition to enrolling law graduates who are facing pending criminal cases, observing that the Advocates Act does not provide for such a disqualification. A bench of Justice Vikram Nath, Justice Sandeep Mehta, and Justice R. Mahadevan was hearing the case of K.R. Sudarshan, a chartered accountant who had later obtained a law degree but was denied enrollment by the Bar Council of Tamil Nadu and Puducherry because a criminal case against him is still pending. Senior Advocate Nikhil Goyal, appearing for Sudarshan, argued that the restriction had no basis in the Advocates Act. He also pointed out that one of the convicts in the Rajiv Gandhi assassination case, after serving over 31 years in prison, had been enrolled as an advocate earlier this year, while his client was being denied enrollment despite only facing pending proceedings. Questioning the Bar Council's stand, Justice Sandeep Mehta remarked that the restriction appeared to be outside the scope of the Act and observed that the Bar Council was enrolling convicts right, left, and center while objecting to the enrollment of a person against whom the trial was still pending. When the Bar Council argued that the issue involved a larger concern, Justice Mehta made a sharp oral observation, saying that the real larger concern was the Bar Council of India granting recognition to law colleges run in garages. The Supreme Court directed the Bar Council of Tamil Nadu and Puducherry to provisionally enroll Sudarshan and enroll his enrollment certificate within 2 weeks while granting time to the Bar Council to file its response. The larger question of whether a pending criminal case can be treated as a disqualification for enrollment will continue to be examined by the Supreme Court. And for our fourth story today, the Supreme Court has stayed a Delhi High Court order that had allowed Devangana Kalita, an accused in the Delhi riots' larger conspiracy case, to inspect electronic evidence collected by the Delhi police but not relied upon by the prosecution. The case arises from a June order of the Delhi High Court, which had refused Kalita's request for copies of protest videos and WhatsApp chats relied upon by the prosecution, citing the sensitive nature of the material. However, the High Court had permitted her to inspect the unrelied electronic records that remained in police custody. Challenging that direction before the Supreme Court, Additional Solicitor General S.V. Raju argued that the court's earlier decisions in Debendranath Padi and Sarla Gupta made it clear that an accused is not entitled to inspect unrelied documents at the stage of framing of charges. He further submitted that such requests only serve to delay the trial. Appearing for Kalita, her counsel argued that the defense was seeking access to videos that allegedly showed her participating peacefully in the anti-CAA protests. He submitted that if those videos established that she was not involved in violence, they could support her discharge from the case as well. The bench of Justice Arvind Kumar and Justice Alok Arade, however, observed that such arguments relate to the defense at the stage of trial and cannot be considered while charges are yet to be framed. Staying the High Court's decision, the bench observed that the law, as laid down in Sarla Gupta, does not entitle an accused to inspect unrelied documents at this stage of the proceeding. The Supreme Court will now examine the legal question while the stay on the High Court's order remains in operation. And for our fifth story today, the Delhi High Court has sought all medical records relating to activist Sonam Wangchuk before deciding his plea to be shifted from Safdarjung Hospital to a private hospital of his choice. A division bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya was hearing an appeal filed by Wangchuk's wife, Dr. Gitanjali Angmo, challenging a single judge's refusal to order his transfer. The court directed Safdarjung Hospital to place on record by way of an affidavit all pathological reports and health bulletins relating to Wangchuk. It also asked AIIMS and the private laboratory that conducted independent tests to place their reports on record, while requesting doctors from both AIIMS and Safdarjung Hospital to assist the court at the next hearing. Appearing for Wangchuk's wife, senior advocate Akhil Sibal argued that Wangchuk had been removed from his protest site without prior intimation and without any medical reports showing an emergency. He submitted that the family had not been given copies of the reports allegedly showing dangerously low potassium levels and argued that a conscious and competent patient has the right to decide where he wishes to receive treatment. Relying on the Supreme Court's judgment in common cause, Sibal contended that bodily autonomy and informed consent cannot be overridden when a person is capable of making decisions. The bench, however, observed that medical decisions must be guided by doctors and questioned whether physicians should wait until a patient's condition becomes critical before administering treatment. It also noted that while the medical reports ought to have been shared with the family, the court's immediate concern remained protecting Wangchuk's life. Appearing for the Union government, Solicitor General Tushar Mehta argued that although bodily autonomy is an important constitutional principle, the state has also the duty to protect life, particularly where a deteriorating medical condition could have a wider public consequence. He submitted that blood samples had been tested at Safdarjung Hospital, AIIMS, and a private laboratory with broadly similar findings. The High Court has now directed all medical reports to be placed before it and will consider Wangchuk's request for transfer after examining the complete medical record and hearing the doctors involved. And for our sixth story today, the Supreme Court has directed the Union government to constitute a committee within 2 weeks to frame uniform guidelines on post-retirement facilities for former Chief Justices and judges of High Courts, observing that the benefits available to retired judges differ widely across states. A bench comprising Chief Justice of India Suryakant, Justice Joymalia Bagchi, and Justice B. Mohana was hearing a petition concerning the security and other post-retirement facilities extended to retired High Court judges. During the hearing, the Chief Justice questioned whether the amounts provided by some states for security arrangements were even practical, asking, in 45,000 to 50,000 rupees, is it even possible to get a driver and security officer? He also pointed to the lack of uniform policy across the state. The court recorded that basic facilities such as domestic help, drivers, telephone facilities, medical reimbursement, and accommodation in government houses presently vary from one state to another. It observed that these disparities had prompted the Association of Retired Judges to approach the court. Emphasizing that such benefits should not depend on the state where a judge happened to serve, the bench observed that there was no justification for these amenities to vary across the country. It requested Solicitor General Tushar Mehta to persuade the union government to set up a committee within 2 weeks to prepare uniform national guidelines along with a mechanism for financial assistance. The Supreme Court has directed that the committee submit its recommendations to both the union government and the court within 3 months of its constitution. And for our next story today, the Calcutta High Court has directed the immediate arrest of Bengal and Delhi Capitals cricketer Abhishek Porel and another accused in a case involving allegations of rape, criminal intimidation, and blackmail. The court has also ordered the immediate seizure of their electronic devices to prevent the circulation of the complainant's intimate photographs and videos. Justice Saugat Bhattacharya passed the order while hearing a petition arising from an FIR registered at Mogra police station on the complaint of a medical student. According to the prosecution, the accused allegedly established a physical relationship with the complainant on the promise of marriage, secretly recorded intimate photographs and videos, and later used those recordings to threaten and blackmail her. The FIR invokes several serious non-bailable offences under the Bharatiya Nyaya Sanhita. Counsel for the complainant argued that despite the seriousness of the allegations, the investigating agency had failed to seize the accused's mobile phones and other electronic devices, raising a genuine apprehension that the complainant's private images could be circulated. It was also submitted that the failure to secure this electronic evidence was affecting the investigation. Noting that no one appeared on behalf of the accused, the High Court directed the officer in charge of Mogra police station to immediately apprehend the accused and seize all relevant electronic devices, including mobile phones and laptops, to ensure that no objectionable material relating to the complainant is disseminated. The court has also directed the investigating agency to file a compliance report detailing the steps taken pursuant to its directions. The matter will next be heard on August 11th. And for a final story today, the Andhra Pradesh High Court has held that a fresh DNA test can be ordered in exceptional cases where a child's right to establish paternity and claim maintenance is directly an issue, even if an earlier DNA report was obtained during criminal proceedings. Justice Venkat Jyotirmay Pratap was hearing a petition filed by a mother and her minor daughter after a trial court refused their request for a fresh DNA examination. The earlier DNA report prepared during criminal proceedings had not identified the respondent as the child's biological father. However, the petitioners argued that they had consistently questioned the report's authenticity and reliability and sought an independent examination by a central forensic laboratory. The respondent opposed the request, contending that the issue had already attained finality and that directing another DNA test would amount to harassment and violate his right to privacy. He argued that the petitioners were merely seeking a second opinion after an unfavorable result. Rejecting that contention, the High Court observed that DNA tests should not be ordered routinely, but this case stood on a different footing because the child's claim for maintenance depended entirely on the determination of paternity. The court noted that the minor child could not have independently protected her interests during the earlier proceedings and held that her rights to identity, maintenance, and welfare could not be defeated simply because the earlier DNA report had gone unchallenged. Observing that a fresh examination by a reputed central forensic laboratory would conclusively settle the dispute without causing prejudice to the respondent, the High Court set aside the trial court's order and directed that fresh DNA profiling be conducted. It also asked the trial court to complete the exercise and dispose of the maintenance proceedings, preferably within 2 months. And that's all for today's edition of LiveLaw Daily. If you'd like to read any of these stories in detail, as always, you'll find the links in the description box below. For continuing coverage of the courts and the law, visit livelaw.in and keep following us here to stay updated with everything that is law.